as you'll be well aware, the government has been considering Teina Pora's compensation application now for some time. This application follows Mr Pora's wrongful conviction and imprisonment on the charges of murder, sexual violation by rape and aggravated burglary in relation to the death of Susan Burdett in Papatoetoe in 1992. Teina Pora was convicted on those charges in 1994 and again in 2000. In March 2015, the Privy Council quashed his convictions and did not order a retrial. As such, Mr Pora fell within the Cabinet guidelines governing compensation for wrongful conviction and imprisonment, and he applied for compensation on the 13th of April 2015. As part of that process, in June of last year, I instructed former High Court Judge the Honourable Rodney Hanson QC to provide independent advice on the application. Mr Hanson provided two reports, the first dated the 23rd of March this year on the question of Mr Pora's innocence, and the second dated the 31st of May on the appropriate amount of compensation. While the issues involved in this case are complex and the charges involved could not be more serious, this has been a considered, thorough and orderly process. I want to put on record my thanks to Mr Hanson for the high quality of both of his reports, which have assisted greatly in the consideration of this matter. While the commentary is likely to focus on compensation, the central and most important finding is that Mr Pora has proven his innocence on the balance of probabilities as the guidelines require, and in fact Mr Hanson notes that the evidence is such that he could have proven his innocence to an even higher standard. Mr Pora has been found to be innocent of the charges on which he was convicted, and the Crown accepts that. And the Crown has apologised unreservedly to Mr Pora for the devastating impact the wrongful conviction has had on him and those close to him. Given an injustice has been done, I have written to Mr Pora to formally convey the findings of innocence and the Crown apology. Mr Pora has asked that I read out that apology here today, and I'm very happy to do so. Dear Mr Pora, I am writing to you on behalf of the Crown to formally apologise to you for your wrongful conviction and imprisonment for murder, sexual violation by rape and aggravated burglary. The Crown accepts that you are innocent of the offences for which you were convicted in 1994 and again in 2000. I acknowledge that over the past 2 decades you have suffered considerably, including the many years you spent away from your young daughter as a result of your convictions and imprisonment. To compensate you, the Crown has agreed to make an ex gratia payment to you of $2,520,949.42. While it can never completely remedy the injustice you have suffered, I hope that the Crown's offer of compensation can go some way in helping you and your family build a better future together. I believe that by and large, New Zealanders enjoy a fair and effective criminal justice system. However, mistakes are possible in any system that relies on human judgment. On behalf of the Crown and the criminal justice system, I apologise unreservedly for the devastating impact the wrongful conviction and imprisonment has had on your life. As I said earlier, I believe that on the whole, New Zealanders enjoy a fair and effective criminal justice system. The New Zealand justice system has a highly regarded, robust appeal process for dealing with people who consider they've been wrongly convicted. Around 85,000 people every year are convicted. 99.9% of convictions are upheld. The few that are overturned demonstrate the system works as it should, with the review of decisions of lower courts being under the jurisdiction of higher courts in the appellate system. But no system is perfect, and I accept that mistakes are possible and are made. It's now clear that the system has erred in this case, and the decisions announced today recognise this. So turning to the issue of compensation. Applying the Cabinet guidelines, Mr Hanson recommended that Mr Pora receive a sum, as I said, of $2,520,949.42 as compensation for his wrongful conviction and imprisonment. Cabinet has accepted that recommendation and has agreed to compensate Mr Pora in the amount that Mr Hanson recommended. I understand that it is proposed that the bulk of the compensation will be paid to a trust that has been established for the benefit of Mr Pora and his family. It's to be expected that there will be a range of views as to the appropriateness of the quantum of the payment, but cabinets across successive governments have recognised the importance of having a publicly accessible set of guidelines that are consistently applied across all cases. Those guidelines include provision for an independent assessment and advice on exactly how they should be applied in each case. That is the process that has been used for the previous 8 people to receive compensation since the guidelines on quantum were adopted, and it is the process that has been applied here to derive the amount to be paid. Today, I have publicly released both of Mr. Hansen's reports so that the basis of his findings can be understood. So in conclusion, as I've said to Mr. Pora, while we can never completely remedy the injustice that he has suffered, I do hope that these findings, along with the compensation offered, go some way towards helping him and his family build a better future together. I'll now take your questions.
What do you say to people who say, aside from all the cabinet guidelines, etc., what do you say to people who say this isn't enough? He spent 21 years in prison.
Well, look, I think cabinets, as I said, under successive governments have recognised that you need to have some sort of process for dealing with these applications. And in 2001, the cabinet at that time decided that a set of guidelines needed to be in place to work through how compensation should be assessed. That is the basis that has been in place for some time. As I said, there will be a range of views from people as to what that figure should be, but it is appropriate that there is a framework in place. And what I don't believe in would be shifting the goalposts during a process. So if, in fact, the guidelines are to be reviewed, they should be done as a review of the guidelines and not an ad hoc change on a case-by-case basis. That would defeat the entire purpose of having a clear and understandable system. In addition, there is a very good reason why we employ an independent QC in this case to go and give us advice on exactly how those factors should be weighed. Cabinet hasn't chosen to interfere with that and has agreed to make the payment that has been recommended in terms of the guidelines as written.
So were any other amounts recommended, or was this the only recommendation?
The recommendation was to pay this amount in terms of the guidelines. Mr. Hansen did suggest that Cabinet consider whether there should be an inflation adjusting of one component. There are 3 components that make up compensation. 2 of them relate to other non-pecuniary loss and actual costs, which are effectively do allow for some updating of figures. The one element of $100,000 per year of imprisonment is the figure that we were asked to consider adjusting. We did consider that. Cabinet decided that that wasn't appropriate for a number of reasons. First of all, the guidelines, as I said, don't provide for inflation adjusting. Now, that's not unusual. There are a number of fees and thresholds across our system that don't automatically provide for inflation adjusting, and the decision is made that they are updated as and when cabinets of the day feel that's appropriate. There is also the reason that every other applicant who has been compensated under the guidelines has not been inflation adjusted. This has been the way it has been approached since the guidelines were in place, and we have to ensure some sort of equity. And probably the most important reason is that the decision that Cabinet made was whether we were still comfortable that the $100,000 per year of incarceration was an appropriate figure. And in making that decision, we were guided by a range of other international jurisdictions and the thresholds they have in place. And the New Zealand figure of $100,000 a year still, I think, sits very well alongside those. For example, in the UK, if you've been in prison for more than 10 years, your total compensation is capped at no more than £1 million. Across a number of states in the US, the compensation per year ranges from a figure around $18,000 up to a maximum of $100,000. So there are a range of approaches, but we were comfortable that our figure remains appropriate.
Is there a time then to review the guidelines?
Look, that's a decision we can certainly have, but the reality is that that would never have affected Mr. Pora's application, because his application will be dealt with on the basis of the guidelines at the time he applied, and we're very conscious that you can't move the goalposts halfway through a process. So it could well be that... It could, just finish the answer, it could well be that the guidelines are looked at in the future, but there's no guarantee that a movement would be in favour of or against any particular applicant's interests. Every aspect of them would be looked at, and that's something Cabinet can turn its mind to in due course, but this application was always going to have to be dealt with on the basis of the guidelines as they were. To answer your question, sorry, the compensation guidelines, 2001.
And is that payment tax free?
I beg your pardon?
Is that payment?
That's my understanding, although I'm not a tax expert.
Rodney Hansen found that there was an irresistible inference that Malcolm Rewa acted alone. Will he be reinvestigated now?
So Mr. Hansen's report isn't a legal finding into the culpability of Mr. Rewa. He was specifically asked to only consider Mr. Pora's involvement. Now, in part of considering Mr. Pora's involvement, obviously the evidence relating to Malcolm Rewa was a factor he considered, but nothing in his report is a finding in respect to the culpability of Mr. Rewa. Any decision in respect of a prosecution of any other party is one for the Crown Prosecution Service and not one that I can comment on.
Sorry, just to be clear, are you recommending that they should review the guidelines?
It's something that I think Cabinet will look at in due course, but what I don't think you can take from that is where any review would land. But what I'm being very clear on is that any review of the guidelines would only apply to cases lodged after the date of any such review, and as I say, we can't anticipate what a review where it might take us.
What assurances can you give that the miscarriages like this won't happen again?
Well, the interesting thing in this case is when you look back through what has happened and you read the findings in Mr. Hansen's, the two of his reports, what he's been very clear on is that while he has certainly found some shortcomings in the police approach at the time, some fault with how they handled things, he also made it very clear that the fault or the responsibility for this very, very tragic circumstance cannot be laid solely at the door of police. He has made the finding that the decision to prosecute was in fact vindicated through the process and was taken on the grounds of good principle at the time, and he's made the finding that, or repeated the fact that the very evidence that in fact established Mr. Pora's innocence, the evidence around fetal alcohol spectrum disorder, was never put before the two courts that heard his trials. So I think what this tells us is that we know a lot more now about the impact of things like fetal alcohol spectrum disorder. We know a lot more about how they affect people. Police practice has come a long way. I think what this reflects is the system now knows a lot more about the impacts of conditions like Mr. Pora's and is in a better position to handle them.
Are you concerned that came up, it was raised by a citizen, this fetal alcohol, and that was what prompted this review, that it wasn't something within the justice sector? Are you concerned that that's what it took for this to be resolved?
Well, look, as I say, Mr. Hansen has done the review of the evidence, and his finding, though, is that is not something that was put before either court. So the defence team obviously have the opportunity to put their case in each of those two trials. This wasn't put before them. I think what it tells us is that at the time Mr. Pora was prosecuted and convicted both in the first trial and the second, the system simply didn't know as much about fetal alcohol spectrum disorder as it now does. I don't think we can regard that as necessarily a failing. I think we can regard it as incredibly tragic. We can take it as being incredibly tragic for Mr. Pora. But the reality is we know more and more about some of these conditions all the time.
So do you think there's anyone within the police force who should have action taken against them? And if not, is there someone who should feel ashamed about their behaviour in this case?
Well, as I said, the reports do point to some shortcomings in police conduct. The report goes on to make it very clear that is not to say that you can lie the responsibility for this tragic outcome at the feet of the New Zealand Police Force. Practice has obviously moved on a long way, and there are a number of other factors. Mr. Hansen makes the point that there are factors on both sides of the equation which led to this outcome. He works through that in his report and effectively comes to the conclusion that the factors on both sides weighed themselves out. In respect of any particular review, that would be a matter for the police and the Independent Police Complaints Authority. Again, it's not for me to make a decision as to what sort of conduct should be or investigation should be taken in that regard.
Are you confident then, given all the changes, that this wouldn't happen again, we wouldn't see this today?
What I think we can be confident of is that the system knows a lot more now about how to deal with people like Mr. Pora, who are clearly deeply affected by fetal alcohol spectrum disorder. That wasn't the case at the time he was investigated, at the time he was prosecuted, at the time of his two trials. That is incredibly tragic, and that's what we're recognising today, that Mr. Pora is innocent, that with today's understanding and what we now know, he should never have been convicted. But it's very difficult to apply the knowledge we have today back to the time from 1992 forward. But there's nothing to suggest that if a similar fact pattern was repeated today, we would get a similar outcome, because, as I've said, the police practice has changed, the courts know a lot more, the medical fraternity knows a lot more, and I have no doubt that evidence would be forthcoming a lot earlier and be a lot better understood.
You said that Teina Pora asked you to read that apology
Yes.
out. Does that mean he's accepted the Crown's apology?
What we have done so far is we've communicated with Mr. Pora's team the Cabinet decision, obviously. We have indicated to him that the Crown unreservedly accepts that he is innocent and that a very tragic wrong has been done to him, and that the Crown apologises unreservedly for the impact on him. The offer of compensation is one that him and his team are working through, and they will go through a process of understanding that to complete the process. And I haven't spoken to Mr. Pora directly, I have spoken to his lawyer, but I understand that he was very pleased to receive the apology, that it meant a lot to him, and his lawyer conveyed that he would like me to read out the apology in full, which I was very happy to do.
Is
Do you know why?
this like a final offer, the compensation? Can they come back to you and state the case for more?
Well, the process for stating the case as to what they believe the compensation should be is done through a process with Rodney Hanson, and that's the process they have done. They've made application to Rodney Hanson, they've made their submissions, Crown Law makes similar submissions, and it is the job of the QC to balance those and make a recommendation. Cabinet hasn't sought to interfere with that, and Cabinet, the decision of Cabinet is effectively one for Cabinet alone. It isn't a decision that is a toing and froing process. Cabinet makes a final decision, but as you know, and as you've seen from the reports we've released today, we have accepted in full Mr Hanson's recommended amount under the guidelines.
Could a future government give Mr Pora more money?
Well,
They
future
top up
government,
that compensation limit?
a future government obviously is free to do whatever it wishes, but as part of making a payment and compensation, it is a recognition by the Crown and the parties that the process is at an end, and that is the basis on which the payment is made.
What are your thoughts on how long this has taken?
Well, look, actually, I think this process has been handled in a very thorough, robust and timely way. When you think that the Privy Council quashed the convictions in March of last year, the application for compensation was made in April of last year, the instructions to Mr Hanson were given in June of last year, and that the final report from Mr Hanson came through just 2 weeks ago, I think to be in this position today represents a very timely process, and with these processes we always want them to be handled as efficiently as possible. How long that takes is always dependent on the particular circumstances of the case.
But to be in jail for over 20 years for something he didn't do, to take that long to get to this point.
Well, as I've said, the tragedy of this case is that the evidence that eventually freed Mr Pora was evidence that was never presented at the first two trials, and when it became available, it was put before the Privy Council. That is what the Privy Council relied on to exonerate him. The fact that it wasn't available earlier is a fact of the reality of modern knowledge around fetal alcohol spectrum disorder. It is incredibly tragic. It is no comfort to Mr Pora. But if more had been known earlier, I have no doubt it would have been put before the courts, and we can only speculate what the outcome might have been.
And your thoughts on an independent commission, perhaps?
Well, actually, I think that the process here shows us that the system does work very well. The Crown doesn't seek to, or the Cabinet doesn't seek to act as judge in these matters. We don't seek to sit there and go through the evidence. You know, we're not finders of fact. We shouldn't sit in that way. What we do is, in each case, appoint the appropriate person with the appropriate legal expertise to give us independent, arm's-length advice. That's what Mr Hanson have done. As I said, I think he's done an excellent job. His reports are very thorough. They're very easily comprehensible, and I think they go through the evidence and the thinking very, very clearly. And I think they establish the fact that actually these processes are absolutely arm's length of the Crown. They're handled very, very appropriately and can work very well.
So that's a no to an independent commission?
I've never supported an independent commission. I think the system as we have it works very well.
Can you give us an update on where you're at now with the David Bain compensation case?
The process is continuing and there's nothing further to say at this time.
Why is that taking so long?
Well, again, there's nothing further to say at this time. We'll let you know when there's more to say.
Will there be any more review of the case, just in particular, just around how these things could be detected, especially bearing in mind that there was a chanciness about this, that it was detected by someone outside the justice system, and that was the key evidence? Will there be any review to work out how this can be picked up earlier within the system? Yeah, well, our justice system relies on the defence, obviously, to understand and put their case and put their defence forward. And I think, as I've said a number of times now, both the legal fraternity, the police, and understanding, dealing with people in this situation and making prosecution decisions, the Crown Prosecution Service, the courts, and the expert evidence that will be brought understand this far better. It's very tempting sometimes to sit here in 2016 and look back with the knowledge we have today and second guess the decisions that were made in the mid-90s. The reality is, with the information they had at the time, I can only take the view that people acted with the best of intentions. Certainly Mr Hanson has not found any evidence of inappropriate pressure on Mr Pora, on any lack of good faith on the part of prosecution. In fact, he notes that police were fastidiously careful in the handling of him. He certainly finds fault in some of the way the police handled the matter, but we shouldn't forget that he has also said that doesn't mean that the failings can be laid entirely at the police. There was a number of factors that have led to what I've said is an incredibly tragic outcome for Mr Pora, and one that we are hoping we can go as far as we can to put right today.
You say the system works well, but it's a lot of people who use their own time and money and resources to fight very hard for Mr Pora over a number of years to get here. That's not the system working well at all, is it?
Well, we've always relied on an adversarial system of justice in this country, which is that the prosecution puts its case, it's up to the defence to put their case and to adduce all the evidence that they think will help their client. And I think it's important to remember, in both of Mr Pora's trials, the evidence around fecal alcohol spectrum weren't put before the jury. It's not as if the evidence was put and disregarded or put aside. The information and the knowledge simply wasn't there. That's not a failing on the defence. We didn't know as clearly as we do today as much about this condition. So the fact that the defence, it is the job of the defence to rally around the information that supports their claim, is our entire system of justice. Now, obviously, we have issues and ways in which we support defendants who aren't well resourced to do that, but the fact remains that it is up to the defence to put their best evidence in front of the court and for the court to make the best decision it can on the information that's in front of it.
What do you say then to those people who did give their time and money and expertise to help Mr Pora out? Do they deserve some kind of congratulations or something from the government as well?
Well, as part of the compensation offer, you'll see that a part of it is to costs, so for the people of the costs of the people who've been involved in this compensation claim in the fight to get to this point. That is included in the process. As I've said, that when that evidence was available, it was put before the court, which by that stage was the Privy Council. The Privy Council accepted it, and Mr Pora was freed without order of retrial, and very quickly we've moved through the process of getting to today where the Crown accepts his innocence and agrees to compensate him.